Good afternoon. Welcome back. We're going to talk about a real exciting option today about what we have as part of our asset protection strategy, and that is our estate planning documents. Now, when people come in and talk to me, they ask me, how many options do we have to do estate planning? And in my opinion, there's about three. And the first option is the most popular option. It's actually the one that most people use out there, and it's basically to do nothing and expect your state to decide what's going to happen to your assets. The probate code actually has something that says if you don't take the time and the effort to decide on your own what it is that you would like done when you're gone with your assets and with your family, then the state will do that for you, and they have made that decision. Now, in the state that I'm in California, they don't think quite like I do. And so the things that they're saying, if I don't make a decision, this is what we're going to do with your things, it's nothing like what I would want done with my things. So I think that first option, doing nothing, is going to be wrong 100% of the time. Okay? Second option is we can use a will. And what is a will? It is a letter that basically says, Dear Probate Court, when I'm gone, I want a certain person to be in charge of my estate. I want a certain person to receive my estate. I want a certain person to be able to raise my minor children. Take the time and take things out of my name and give it to someone else. That's what the will says to the probate court. Now, what is probate? Probate is a legal proceeding that goes through the courts, and it's basically so the court can take things out of your name and give it to somebody else. In some jurisdictions, it takes 6 weeks to do this. In other jurisdictions, we've gone through probates. It takes about 4 or 5 months. In California, with the COVID thing going on right at the moment, it's actually taken between 2 and 3 years for an average probate. And now, in some jurisdictions, the attorneys and the executors get paid an hourly wage for what's happening. But in California here, they actually get a percent of the estate. The attorney that takes it through probate gets a percent, and the executor gets a percent. And then the court gets paid certain things, and there's some expenses going on with that. So in California, if you add up the minimum expense to be able to take care of a probate in California, it takes about $15,000 to go ahead and do that. So it's not people's favorite way to go. And so we use wills most of the time for small estates where there's less than $164,000, okay? There's no real property involved. Then we can go through a different process called small estate administration, where we don't have to go through the full probate on that. But the moment you have a home, or the moment you have assets over $164,000, then they are required to go through the probate process. And the probate process, like I said, takes about 2 to 3 years. Minimum amount is $15,000. Not a great idea. So if you have a larger estate, something larger than what is necessary to go through that small estate administration, we go to the next option. And the next option is the use of what we call a living trust. Now, a living trust and a revocable trust and a family trust are all the same thing. So it's just a different way of saying the same thing. So the reason we like to use the word living in there is because it's something you did during your lifetime. Because there are some trusts that are set up through wills called testamentary trusts, which just means the will says, Court, would you please set up a trust for me? We don't usually use these in California because it gets the court involved in what's happening with our estate. And so we will use a living trust rather than a testamentary trust generally in California. So what does a trust do? A trust is basically creating an entity that will be able to hold your assets. Let's imagine that we're going to call this entity a box, okay? And the box is called trust. And we take the box and we put everything you own into the box during your lifetime. So we put your house into the box, we put your car into the box, your bank account, your investment account, your wife's diamond ring, your dog, your socks, your shoes, everything ends up in this box that you own and that you control. control. And you can take things out of the box, put things back into the box, change things around. It's all up to you. You get to do whatever you want with what's in the box. When one of you passes away, then the surviving spouse will generally still have that box and still continue to be able to use the box, depending on what your circumstances are. And then when you're both gone, then what happens is we have a new person step forward. They're called a successor trustee. And successor trustee means just the next trustee. So you're the initial trustee. Now we have a new trustee. And this person's job is to pay your final bills. In my clients, they have a free consultation with me to find out what needs to happen and then distribute the assets the way that you have determined in your trust to distribute them. So it makes it really simple. How long does it usually take? The average time in our office to take care of a trust administration is between 40 and 90 days, compared to the 2 to 3 years that a probate takes. Okay, how many probate fees do you have to pay? None. There is no probate. So yes, there may need to be something paid to take care of the deed or do something like that, but the cost to take care of trust administration is very, very low compared to what it would be to run a probate. Okay, so the deal is we create this trust, and now it gives us several different opportunities. Okay, number one, it gives us the opportunity to control our assets even after we're gone. So I'll give you an example. I have 6 children, okay? 5 of them were born within a 10-year period of time, and I had one that came 10 years later to join the group. Now, the ones that were born within that 10-year period of time, they're between 33 and 43. And so they're old enough to receive an inheritance. If they haven't figured out how to work with life yet, they probably won't. But this 23-year-old, my youngest, she still needs to be able to learn a little bit more. So in my trust, I can sit there and say, nobody gets their inheritance until they hit 25. Prior to 25, we hold the money into the trust, we invest it on their behalf, we use it for their college education, we use it for support if they're minors, medical expenses, that type of thing. But we can also basically say, but no fast cars, no trips to Europe, no full body tattoos, no gigantic game cubes or trampolines. So the deal is we have some control over what happens to our assets afterwards. Now at 25 or 30 or whatever the age is that you feel that a person matures, then it's up to them. And we just hope that they're going to be wise in their decisions. All right. So having this trust gives us the chance to be able to control it at that time. So another thing that the trust does is that there is an opportunity in a couples trust where there 2 people are owning things. If you own them together in a community property state, we can get rid of all the capital gains tax on anything that you own when one of the spouses passes away. So we get what's called a step up in basis, which means we take the basis, whatever you paid for it, and act like you paid for a current value, and there's no tax on any of that difference. And so the nice thing is we're able to, the surviving spouse can sell the house, sell the investment account, sell the rental, have no tax on it at all. So that's one of the nice things we can do in the trust. If you have a large estate, we can do things to lower death and estate taxes. We can go ahead and make sure that gift taxes would not have to be paid in most cases. We're able to do some other nice things to be able to make sure that your beneficiaries, your heirs in the end, receive as much of what you have as possible. So there's a lot of other things we can do with trusts, and we're going to get into some irrevocable trusts, different type of business trusts and things like that as we go along. But for right now, just to let you know, the trust is here to make sure that your assets go to your family in the most efficient way possible. So a trust is kind of like the foundation of all that we do. If you sit there and you decide to do a corporation and you don't have a trust, you started in the wrong place. You need to have the trust first, okay? If you start with a limited partnership to protect your assets, but you don't have a trust, all those assets will be going through probate anyway. Because you don't have the trust, you need a trust. So we want to this is where we start. We go ahead and create the foundation as we're putting things together. Now, next time we get together, we're going to talk about how to use a trust and a limited partnership and maybe a corporation or something together so that we're starting to get some asset protection benefits. So far, we've just shown you some of the tools in the tool belt. We're going to want to make sure that we can show you how you get to keep what is yours by putting the proper structure together. So we'll see you soon.